I hereby sentence him to suffer death.
The death penalty is back in the spotlight. In recent months, Ugandan courts have handed down capital sentences in a series of high-profile murder cases. But the judiciary says this is not about judges becoming more punitive.
Why are we now having the trend? Because society needs to be safeguarded. A lot has been happening, there's a lot of impunity. So the courts are speaking to the public that some of these crimes and the impunities should stop, because this is what you will face if you come to the courts and the courts are satisfied with evidence that you committed those offenses.
One of the most closely watched cases is that of businesswoman Susan Magara, who was kidnapped and murdered in 2018. The High Court convicted 9 people over her killing. 2 of them, Hajara Nakandi and Abbas Musa Buembo, were sentenced to death, while the others received different prison terms. The case brought back memories of one of Uganda's most notorious kidnappings and murders. Then came the murder of former Ndiga Clan leader Daniel Bbosa. 2 men convicted of his murder were sentenced to death after pleading guilty. The court found the circumstances of the killing sufficiently grave to warrant the maximum punishment. In April this year, Christopher Okello Onyum was also sentenced to death after being convicted of killing 4 children at a nursery school in Gaba, in the capital Kampala. 3 very different cases, but all ending with the same ultimate punishment. So, is Uganda seeing a new era of capital punishment? The judiciary says not necessarily. It argues that judges are applying the law to the cases before them, and where the circumstances meet the legal threshold for a death sentence, that is the punishment imposed.
As a judiciary, we apply the law as it is, and we don't apply it in a vacuum. You will notice that the courts speak through their judgments and decisions. And so if you are processed and even convicted, the courts will apply the law. And that's the law the courts have applied.
But the debate has another dimension. President Yoweri Museveni has repeatedly spoken in support of the death penalty and has argued that it should be used against people who commit particularly serious crimes. That raises questions about whether such political statements could influence sentencing. The judiciary says they do not. It insists judges remain guided by the law and the evidence before them, not by statements from the executive.
I am not competent to comment on what the president said, but as a judiciary, we apply the law as it is, regardless of any other person's opinion.
But a death sentence does not mean an immediate execution. A person sentenced to death has a right to appeal. That means a case can continue through the judicial system long after the original sentence has been pronounced. And this is one reason Uganda has accumulated people on death row, despite having gone decades without carrying out an execution. The judiciary says this is not a failure of the courts to act. It is part of the legal safeguards available to a person facing the ultimate punishment.
Even when the Court of Appeal has listened to the appeal, if any, and say confirm the sentence of the lower court, still the matter must go to the Supreme Court, because the Supreme Court has still, we are talking about deprivation of one's life by reason of a sentence of court. So there must be all steps necessary to ensure that nothing was rendered by mistake or otherwise.
There's also a constitutional division of responsibility. Judges determine guilt and sentence. The condemned person can challenge that decision through the courts. And ultimately, the president has the final say on whether a death sentence is carried out. So the process can stretch for a year or more, from trial to appeal and potentially to the final decision on execution. For victims and their families, justice can mean punishment and closure. For the accused, it means due process, right to life and the right to challenge a conviction. And for the judiciary, the stated objective goes beyond either side. It says its purpose is to use justice and the law to make Uganda a safer and better society for everyone.
Justice is due and repeat. It cannot be for the accused persons alone. Even the relatives of the person upon which the charges are leveled against the accused persons are equally hurting.
We cannot discriminate anyone in the application of the law, neither should we fear or favor a particular section of a people as we do our functions as a judiciary and as judicial officers. So our guiding principle is Article 126. And of course, we get comfort in Article 128, which gives us and guarantees the independence. That while we are executing our mandate, we shall be independent of anyone.
But the renewed use of death sentences leaves Uganda confronting an old question in a new way. If courts continue to impose the ultimate punishment, while appeals can take years and executions remain rare, what role does the death penalty actually play in Uganda's justice system? For the judiciary, the answer is straightforward. Where the law provides for death and the circumstances of a case justify it, the courts must apply the law. But the larger debate over deterrence, punishment, judicial independence, and whether Uganda should retain the death penalty remains far from settled. Daniel, Kibet, NTV.